Hi everyone, welcome to this session on legal news update. In this channel, every Friday, regularly, we will be updating the weekly legal news and also the current affairs that is relevant for your common law admission test as well as other law entrance examinations like ALET, SLAT, and all the other examinations that you will be writing in addition to CLAT. So, as you know, that CLAT asks this passage-based questions, and these passages could be from anywhere. There are several web portals from where these passages can be taken. There are mainstream newspapers from where these passages can be taken. So in this session, we will take those topics, those issues that have the potential to be in your CLAT paper, the kind of passages that you might encounter in your CLAT paper. We will discuss those kind of passages. We will analyze those passages. We will see the kind of questions that can be formed from those passages. So today is the session, and every week we will be updating this session. So stay tuned with this channel and spread with all your friends regarding who all are writing CLAT 2023 and want to be stay updated regarding all the current affairs and the legal news that is relevant for CLAT and other law entrance examinations. So let us begin. This is a weekly legal news update from 14th October onwards. Just give me 1 second. Okay. So this article has been taken from the Indian Express, which talks about the reservation and the criteria for reservation. As you might be aware that we get reservation from Article 16 of the Constitution of India. What does Article 16 of the Constitution of India says? Article 16 says that there shall be equality in opportunities in public employment. That means in the public employment, in the government services, everybody should have equal opportunity to get a job. Now, how will everybody will have the equal opportunity to get a job? So all the factors have to be taken into considerations, including the historical factors. Say, for examples, the reservation for scheduled caste and scheduled tribes. Historically, certain tribes, certain castes have been not given sufficient representation in the mainstream strata of the society. So now that India is independent, now that the constitution makers came up with their own constitution, they included a provision for a reservation that they should be given equal opportunity in matters of public employment. So people belonging to scheduled castes, scheduled tribes, they have certain seats reserved, be it your competitive examinations, be it your offices at the time of promotion, so on and so forth. But this has always been an issue of controversy. There have been so many disputes regarding that. Sometimes criteria has been set, say for example, for other backward class, the creamy layer criteria has been set that okay, now these people have sufficient representation. Now everybody should not get reservation benefits, but only those who do not earn from a specific threshold. Then economically weaker section was also one criteria that was taken into consideration, that those who are economically weak, 10% reservation should be given to them. So this is a very old discussion, and such kind of discussion might appear in your CLAT paper in one of the passages because it has direct relation with the Constitution of India. And as you might be aware that the CLAT usually asks passages from majorly four areas, that is tort, contract, constitution and criminal law, in addition to any other area that you might come across, because there is no fixed pattern, there is no fixed schedule that they will only target these four areas. It could be anything, but frequently ask these other areas, so at least these should be on your fingertips. So this is talking about the criterion for SC status, who should be given the scheduled caste status. What is the criteria, on what basis should anyone be given SC status? That is very important. Then only we will decide or determine who will get the reservation benefits. So why are Dalit Christians and Dalit Muslims excluded from the Constitution Scheduled Caste Order of 1950? As you might be aware that the caste system is mostly historically is said to have been existed in the Hindu setup, that is to say the Varna setup. So we have the Dalits, there is a Shudras, we have the Kshatriya, we have the Brahman. So this Varna system essentially emerges from the Hindu texts, Hindu practices. So the four Varnas, that is Brahman, Vaishya, Kshatriya, Shudra. So this division can be found in the Hindu tradition. So what about the Christians and what about the Muslims? Can they be also considered as a scheduled caste, someone who did not get sufficient representation, or is it only restricted to the Hindu? So that is one thing that is taken into consideration in this article. So, on what basis were the Dalit Sikhs and Dalit Buddhists added to the order in 1956 and 1990 respectively? So, it is giving you information also. What information is it giving you? It is giving you that Sikhs and Buddhists, as you might be aware, that Hindu as a religion is very vast, and Sikhism and Buddhism in some form emerged from the overall ideology of Hinduism only. So Dalit Sikhs and Dalit Buddhists were added to the order. In 1956, Sikhs were added, 1990 Buddhists were added, but Christians and Muslims, why are they not added? That is the essential question that the author is raising in this paragraph. The story so far: the Supreme Court of India has sought the most recent petition of the Union government on a bench petitions challenging the constitutional scheduled caste order of 1950, which allows only members of Hindu, Sikh, and Buddhist religion to be recognized as scheduled caste. So, this is the story so far. So, who all are included in the Constitution Order of 1950? When enacted, the Constitution Scheduled Caste Order of 1950 initially provided for recognizing only Hindus as scheduled caste, that is SCs, to address the social disability arising out of the practice of untouchability. Now, please remember, Article 17 of the Constitution of India abolishes untouchability. You must be aware of the basic requirements, that is, the Constitution of India was adopted on 26th November 1949, and we adopted it on that day, and it came into force on 26th January 1950. So these dates are very important, and when it came into force, we have certain fundamental rights, we have certain fundamental duties. Duties were added later by 42nd Amendment in 1976. We have certain directive principles of state policy. So under fundamental rights, which starts from Article 12 to Article 35, we have so many fundamental rights. Like Article 12 talks about that what is the definition of a state? What do you call a state? Why is it important? Because you can have fundamental rights only against a state. So if there is an infringement of a fundamental right, you can ask for the enforcement only against if that body is state. Otherwise, for a private body or for other individuals, you cannot ask for the enforcement of fundamental rights. Then we have Article 13 that talks about the judicial review. If, say, for example, the legislature, the parliament, or the state legislature has come up with any law which infringes your fundamental right or against the constitution, then the Supreme Court has the power to strike off that law. So that is called the power of judicial review, which is given under Article 13. Article 14 talks about equality. Everybody has equal protection of law. Everybody is equal in the eyes of law. Article 15 talks about that the state shall not discriminate against anyone on the basis of race, religion, caste, sex, place of birth, or any of them. Article 16, I just mentioned in the beginning of this session, is about equal opportunity in matters of public employment. Article 17 abolishes untouchability. Untouchability, the practice of untouchability that is mentioned here in the passage. The order was amended in 1956 to include Dalits who had converted to Sikhism, and once more in 1990 to include Dalits who had converted to Buddhism. We saw this thing in the previous paragraph that in 1956 Sikh Dalits were included, in 1990 Buddhists were included. Both amendments were aided by the reports of the Kaka Kelkar Commission. This is very important. These committees, these commissions that give the recommendations according to which the laws are formed, according to which the parliament makes the law and makes the provision for them. These are very important. The name of the committee and the chairperson, it's usually named after the chairperson. So it is very important. Kelkar Committee is regarding this only. In 1955, and the High Powered Panel HPP on Minorities, Scheduled Castes, and Scheduled Tribes in 1983, respectively. On the other hand, the Union government in 2019 rejected the possibility of including Dalit Christians and members of SCs, rooting the exclusion of an imperial order of 1936 of the then colonial government. Then colonial government means Britishers. We're talking about 1936 when India was under Britishers. India got independence in 1947. We got the constitution in 1950. So 1947 was the date India got independence, but 1936 we were still under the colonial government, that is the Britishers were ruling us, which had first classified a list of the depressed class and specifically excluded Indian Christians from it. So in 1936, Indian Christians were excluded from the depressed class, and in 2019 we relied on that decision, and we also rejected the possibility of including Dalit Christian as members of scheduled caste. So this is, who all are included in the constitution order of 1950 and on what basis. So still the story remains the same, that Christians and Muslims are not included, and that is the petition, that is the question, that is why this the whole discussion, that why only Hindus, why only Dalit Sikhs, and why only Dalit Buddhists are being included as a scheduled caste and not the Dalit Christians and not the Dalit Muslims. That is the question. So moving on. Why are Dalit Christians excluded? Let's see. Ever since the amendment to include Sikhs as SCs in 1956, the Office of the Registrar General of India has been reluctant in expanding the ambit of the order beyond members of Hinduism or Sikhism. Responding to the Ministry of Home Affairs 1978 request for an opinion on the inclusion of Dalit Buddhists and Christians, the Registrar General of India had cautioned the government that SC status is meant for communities suffering from social disabilities arising out of the practice of untouchability, which is noted was prevalent in Hindu and Sikh communities and not in the Christian community or the other communities, the Buddhist communities. So it is also noted that such a move would significantly swell the population of SCs across the country. So if we start including Buddhist as well as the other requested Christians, so that will make the number of scheduled caste too much. So what will be the consequences of that? Of course, accordingly, we will have to give reservations. There will be too much reserved seats if there are so many number of people who deserve reservation, who demand reservation, who are eligible for reservation. So that is why the Registrar of India has been reluctant. They included Sikhs as SCs in 1956, but after that they became reluctant. That this way, if we start including every request that comes before us based on any ground that they might have, then that will swell the population of SCs across the country. So that is why the Dalit Christians are excluded. However, the amendment to include Buddhist converts as scheduled caste was passed in 1990. So despite their reluctance, here we are talking about 1956. 1956, after including Sikhs, they were reluctant. But still, after that, this step was taken. 1990, Buddhists were included, which at the time did not acquire the approval of the RGI, the Registrar General of India. A mandate introduced in the rules for inclusion framed in 1999. So although the RGI was reluctant, but they did not require their approval. In 2001, when the RGI again opined against including Dalit Christians and Muslims as scheduled caste, it referred to its 1978 note and added that Dalit Buddhists, Dalits who converted to Islam or Christianity, belong to a different sets of caste groups and not just one, as a result of which they cannot be categorized as a single ethnic group. So they are trying to categorize that into certain things, that those who converted to Islam, those Dalits who converted to Christianity, they belong to different set of caste groups and not just one group, that okay, these are untouchables or Dalits and now they are Muslims or now they are Christians. No, that is not the same. So it cannot be categorized as a single ethnic group, which is, and why is it important? Because it is required by clause 2 of the article 341 for inclusion. Moreover, the Registrar General of India opined that since the practice of untouchability was a feature of a Hindu religion and its branches, allowing the inclusion of Dalit Muslim and Dalit Christians as SCs would result in being misunderstood internationally. You understand that that's the Varna system that I mentioned in the beginning of the class, that there is Brahman, there is Vaishya, there is Brahman, Vaishya, uh, what is that? Kshatriya and Shudras. Brahman, the priestly class, the Vaishya, the businessman, the people who are traders. Then we have Kshatriya, the warrior class, and the Shudras, the service class, or essentially those who are serving the people. Then there are mythological and religious connotations, that how they emerge and everything. All that there is in the Hinduism, in the Hindu tradition. So internationally, that is the image, that untouchability arose from the Hindu and those the offshoots of Hinduism. If we start giving it to say Christians, or if we start giving it to say Muslims, then that will be misunderstood internationally. So that is one argument, as India trying to impose its caste system, because of course in the West you will have more cases of Christians, or in the Gulf countries, in the Arabian countries, you will have more cases of Muslims. Even in Afghanistan, Pakistan, you will have more cases of Muslims. So if we start giving caste status, scheduled caste status to Muslims, to Christians, the international community will think that we are trying to impose our caste system on Christianity and Muslims. So that will have a different effect on them, upon Christians and Muslims. The 2001 note also stated that Christians and Muslims of Dalit origin had lost their caste identity by way of their conversion, and that in their new religious community, the practice of untouchability is not prevalent. And the Muslims and Christians, those who are of Dalit origin, now that they have converted to Christianity, now that they have converted to Islam, they have lost their caste identity. They are no more that untouchables and Dalits, because now they are converts. So now that they have lost their caste identity, so the practice of untouchability is not prevalent. Then it is not, they should not be, in a sense, in the same league as, say, the Hindu Dalits, or even the Sikhs Dalits, or later added Buddhist Dalits. So not in the same league, essentially. That is what the passage is trying to say. So is there a case of inclusion? Can the Christians, can the Muslims be included as a, as Dalits, as the scheduled caste? The petitions arguing for inclusion have cited several independent commission reports that have documented the existence of caste and caste inequalities among Indian Christians and Indian Muslims, noting that even after conversion, members who were originally from the scheduled caste continued to experience the same social disabilities. So here there is a petition that is arguing in favor of inclusion, and they have cited several independent commissions, just like we discussed about Kaka Kelkar committee. So they cited several independent commissions reports, and they said that even after they have converted to Christianity, even after they have converted to Islam, there is still is there a same social disability because they converted from Dalit to Christianity, from Dalit to Islam. So it exists, the disability exists. This was substantiated in the first Backward Class Commission's report in 1953. The report of the Committee on Untouchability, Economic and Educational Development of the Scheduled Caste in 1969. The high-powered this report on Supreme Court, Scheduled Caste and Scheduled Tribes and Minorities in 1983. The Mandal Commission report, the report on Prime Minister's High Level Committee formed in 2006, a 2008 study conducted by the National Commission for Minorities, the Ranganatha Mishra Commission report, and several other studies. So, see, so many committees, so many commissions, so many high powered these committees and commissions, they have highlighted the fact that even after converting from being a Dalit, from being an untouchable to becoming a Christian, to becoming a Muslim, that the social disability still exists. They are still discriminated. They are still not given representation in the mainstream of the society. So all that thing, this was substantiated in all these reports. The first Backward Commission report in 1953, the report on Committee on Untouchability, Economic and Educational Development of the Scheduled Caste in 1969, the HPP report on Scheduled Caste and Scheduled Tribe in 1983, Mandal Commission report, the report of the Prime Minister's High Level Committee formed in 2006, a 2008 study conducted by the National Commission for Minorities, Ranganath Mishra Commission report, several other studies. In addition to this, the petitions have argued that against the proposition that caste identity is lost upon conversion, noting that even in Sikhism and Buddhism, casteism is not present and yet they have been included as SCs. So, simple argument that if your argument is that by converting your caste identity is lost, then why are you giving the reservation or including the Buddhist and Sikhs in the scheduled caste? Because they also converted. They converted to Sikhism. They converted to Buddhism. If you are giving them if you are including them in the scheduled caste, why not the Indian Christians? Why not the Muslims? That is the question here. So, furthermore, the above mentioned reports argue that the caste-based discrimination continues even after conversion, hence entitling these communities to SC status. So, all the committees that we mentioned, that even after conversion, the discrimination continues. So, they are entitled to get the scheduled caste status. However, the union government refuses to accept the reports of the commissions. On what basis? On the basis that these reports do not have enough empirical evidence to support their claim. These reports they are not accepting outrightly. They are saying that they do not have empirical evidence. These are opinion based. These are maybe data based, but the data is not empirical. Advocate Franklin Caesar Thomas, one second. Advocate Advocate Franklin Caesar Thomas, who represents some Dalit Christian bodies, said that such empirical evidence do not exist for including Sikh or Buddhist converts either, and yet they were included as SCs in 1956 and 1990 respectively. So if you are talking about that there is no empirical evidence, then why did you include the Sikhs and Buddhists? If you are saying that there is no empirical evidence for Christians and Muslims, then there was no empirical evidence for Buddhists and Sikhs as well. So if you have included that on that ground, so what is the ground? What is the basis essentially for not including Christians and for not including the uh, Muslim? Dalits in India as scheduled caste and scheduled tribes. So this was the uh, one passage that talked about so many committees, so many commissions, so many complex issues that involved not only the history but also the politics, the polity of the matter that you should be aware of, because these are the kind of passages that you will be coming across in your CLAT paper. Let's look at the other the rest of the passage. Is this the first time in the government that the government has considered this issue? Is this a new issue that we are discussing today? The closest the government has got to including Dalit Christians as SC came in 1996. So it is not the first time. It happened in 1996 also. They were almost about to include Dalit Christians when, based on a recommendation of then Ministry of Welfare, PV Narasimha Rao. As you know that PV Narasimha Rao has been the Prime Minister. So PV Narasimha Rao government first brought a bill to amend the constitution, scheduled caste order accordingly. So in 1996, the government was this close to bringing the Indian Dalit Christians into the scheduled caste. When this could not be passed, the government within days attempted to include Dalit Christians as SC through an ordinance. So when the bill could not be passed, they tried to include it through the ordinance. You know the ordinance power of the president when the parliament is not in session under Article 1, 2, 3. Please remember these important articles that are very relevant. Article 1, 2, 3 gives the ordinance power of the president. When the parliament is not in session, the president can issue an ordinance. So when the parliament comes for the session, then it looks at the ordinance and makes it, then it becomes a bill. So through an ordinance which was sent to the President of India for assent after the due approval of the erstwhile Prime Minister, but could not then be promulgated. So they tried, but it could not be promulgated. It could not happen. The bill could not pass. The ordinance could not be promulgated. Following this failed attempt in 1996, the Atal Bihari Vajpayee government had in 2000 repeatedly sought the opinion of the Office of the Registrar General of India and the then National Commission for Scheduled Caste and Scheduled Tribes on whether Dalit Christians could be included. Both had recommended against the proposition. So not only Narasimha Rao but also Atal Bihari Vajpayee government repeatedly asked the advice, asked the opinion, and they were advised against it. They had recommended against the proposition that do not include Indian Christians into the scheduled caste. Apart from this, several attempts have been made from time to time by way of introducing private member bills to amend the constitution order to include Dalit Christians and Dalit Muslims as scheduled caste. But these members, numbering at least 20, have all failed. So there have been at least 20 private member bills. So there was attempt by the PV Narasimha Rao, there was attempt by Atal Bihari Vajpayee, there were at least 20 private members bill, all trying to include Indian Christians and Indian Muslims and under the category of the scheduled caste, but all of this failed. Now this issue has emerged again and it remains to be seen what happens now. So this was the passage, and this is the kind of passages that you will be expecting in your CLAT paper. Now there can be so many types of questions. You see, there can be questions like which of the following is true regarding including Indian Christians. So there can be four options like uh, the atrocities that the Hindus, Dalits faced are not the same as that of the Christians, or after conversion, the social disparity does not exist. Or there can be questions like which of the following committees recommended the inclusion of Indian Christians, similarly, there can be questions like which of the following governments tried to include Indian Christians into the scheduled caste. So there can be options of Narasimha Rao, Atal Bihari Vajpayee, private member bills. So similarly, there can be in one passage there can be there is usually 5 questions in one passage. So in this passage, There could be questions regarding what is the reason for inclusion of uh, Dalits, Dalit Buddhist and Dalit Sikhs as the scheduled caste, but not the Indian Christians, Indian Dalit Christians and Dalit Muslims as the scheduled caste. So there can be several types of questions that can be formed from this passage alone, and this is the latest discussion that is happening in the parliament. In the If you will go through the newspapers, you will get to see this again and again. So one second, sorry, one second. Okay, so this was about it for this session. I will see you in the next session regarding some other issue that is burning issue that is very relevant for your CLAT paper, that you might come across in your CLAT paper, and how the kind of questions that can be, that will arise in your mind when once you read the passage. It is very important to read the passage and tackle the questions that arises in your mind, because it is being discussed. The author is saying something, he's giving counterpoints, he's giving citations, he's giving the names of the committees, giving the names of the governments that tried it, giving the counter view, giving both sides of the coin. So you should be very observant in while reading the passage, that how to analyze all that, and the questions that arise in your mind. You should observe those questions, so that when you actually see those questions, that's how your brain should start working. So this was for this session. I'll see you in the other session next Friday on this channel. Please spread this word and keep following this channel for regular update, for regular analysis, for regular the kind of passages that you will be getting in your legal reasoning. And also, the Consortium of NLU has released the sample papers. Go to the official website of the Consortium of NLUs, look at the sample papers, and you will realize that the legal current affairs is very important for you to know for this year's CLAT. So that's it for right now. Thank you so much. Visit the website. Keep stay in touch with this channel, and we will keep analyzing and updating the videos for your analysis. Thank you so much.